Doesn't matter.
Yes, sir.
Okay. Shall I
Yes,
begin, ma'am?
Priyanka will start. Yeah.
Yes, ma'am. Hello, everyone. Namaste and a very good morning.
We have to examine them, the veracity, what they are speaking before the court. Mainly, the judgment is based on the statement of the witnesses. So, sir has consented. I want to thank to sir in spite of his busy schedule, because admission process is going on. CET process is there, and it is the last stage, very crucial stage, where we have to devote our time to the college. In spite of his busy schedule, sir has agreed and consented to interact with our students. Sir, I'm very thankful to you. And once again, I welcome to you at this platform, sir. Thank you.
Thank you, ma'am, for your kind and generous words. It's a great pleasure for me to introduce our learned resource person, Dr. Vijay Matnikar, sir, who is going to share his expertise, knowledge, and experience on the examination of witnesses with all of us. Sir has completed his education and secured the degree of Bachelor of Sciences in Agriculture, Masters of Law, Doctorate in Law, and has also qualified the NET examination. He has expertise teaching experience and has always and has also worked at the Bharatiya Vidyapit, New Law College, Pune for the year 2008 and 2009. He is presently working as assistant professor at Shivaji Law College, Parbhani since 2009. We are very glad, sir, that we are having this opportunity to interact with you and have your guidance on this very important topic of law of evidence. To you, sir.
Thank you. Thank you, Priyanka. Basically, I'm very much grateful to Honorable Principal, my colleague friend, Dr. Poonam Madam, and the institution which provided me this platform to interact with the students of your college. So I'm grateful to all of them, and I'm equally thankful to all the participant teachers as well as students who are present very at the meeting that we are having right now. Politely, I must submit something. Both Honorable Dr. Poonam ma'am and Priyanka called me as a teacher, but I always felt I am a student of law. And I would feel always proud to be a student of law. And in that connection only, I will be having a dialogue with you. So this is a humble submission in front of all of you. And while dealing with the topic, basically, I'm very much thankful to Honorable Principal, because it was she who gave me liberty to choose the topic of my choice. And I feel the person who thinks and speaks his own mind, he must be provided with that kind of liberty. And therefore, I am very much indebted towards her for providing me that kind of liberty. So these things are certainly important for us, and this is basically a Sunday holiday, and still you showed interest in joining the discussion with regard to the evidence. So I understand there are certain people who always believe in learning something, and I am also happy that I am also part and parcel of such kind of a community, and you all participants are the part and parcel of that kind of community. And with this short kind of expression of my ideas, I would like to take to the topic of discussion of today. Basically, the law of evidence, and the major part of it is Indian Evidence Act. So what I will be doing in this lecture, that kind of a kind of roadmap I would like to present in front of you. Friends, basically, I'm not going to tell you what is the section and what to take to you to how to see, how to visualize towards these sections, and that too philosophically. So I will be referring the sections vary less, and I will be emphasizing more and more upon the concepts that are important to be discussed in the context of our today's topic. So let me share with you the PowerPoint presentation that I have prepared for you. Are you able to see my screen?
No, sir.
Not yet, sir.
No, sir.
Okay, let me see.
Yes, sir.
Yes, sir. Now
Yes,
it
sir.
is visible.
Okay, okay. Yeah. Due to the internet, uh, it has to travel certain distance. I think that might have taken time. Okay, so I will just make it the slideshow. Is it visible right now?
Yes, sir.
Yes, sir. Yes,
Okay.
Yes, sir.
Okay. See, around 1 hour and some few minutes would be the discussion of today on this topic of examination of witnesses. And firstly, I will show you, I will share with you the roadmap, how the discussion will be taken forward. And at the end of my lecture, we'll be having a question answer session. In this lecture, I'm also going to use certain videos that are from popular movies, and that too in the connection with the topic of today. Friends, my topic that I'm going to deal with today would be covering all these points. Firstly, I will be dealing with what is examination, what is examination of witnesses, what are witnesses in a brief. Then I will be dealing with order of production and the examination of witnesses. Thereafter, what the judges do, how the judges perform the duty to decide as to admissibility of evidence, what is the order of examination, what are the kinds of examination, and lastly, what kind of questions that are being allowed to be asked during the various examinations, which are part and parcel of judicial proceeding. So, firstly, I will try to understand what examination is. Since last 2 years, we are facing a kind of the pandemic of corona, and how the corona was identified after due close careful study by the scientists. So when we refer the word examination, we have to take into account what actually is an act of examination. Examination is an act of looking at something very closely and carefully. It is also kind of a close and careful study of something. So what we are going to do is, or what the court does is the careful study of a particular kind of an object. And what kind of object it is? It is the witness. So examination of witness, we have to understand in such a way that it is basically an act of looking at something closely, very carefully, and a kind of a careful study is to be done as far as the examination of witnesses is concerned. So as we know, Bentham has rightly stated, witnesses are eyes and ears of the court. When we take into account the whole of the Indian Evidence Act, it can be divided into three major parts. First is relevancy of fact. Then second is the proof of those relevant facts. And third is how to produce those proof before the court. And basically the topic that we are going to deal today is connected with the third category, the last category of Indian Evidence Act, that is the production. So what we have to see, if there is any kind of legal dispute that has taken place on some particular day and the court was not present over there, but somebody was there who has witnessed that kind of a particular kind of a dispute or certain relevant things with regard to that dispute, that has also heard certain kind of important facts with regard to that legal dispute, and that person comes before the court and shares the own experience. Therefore, it has been called as the witnesses are called as eyes and ears of the court. Then, taking into account two different concepts that is examination and the witnesses, we can conclude the examination of witness as it is a kind of a careful, critical analysis of witnesses in order to determine veracity of them being trustworthy. Veracity, that means satyata. Trustworthy, that is vishwasaharta. So in order, if somebody is coming before the court with such kind of information and sharing with the court will not rely upon it. So it is not good to rely directly upon the witnesses. It is necessary to analyze, investigate whether the person who is coming as a witness in the witness box is really having a kind of information with him, or he is just imagining, or a kind of a doctored kind of a witness. That has to be studied, and therefore the examination of witness is important as far as the law of evidence is concerned. My dear friends, you might have seen a railway. An engine leads the railway. So whenever the railway enters into any kind of station, first entry is of the railway engine. Thereafter, the wagons come, and lastly, the room of the guard, the coach of the guard that comes to the kind of platform. So this is what the order. The same way, when we talk about examination of witnesses, there is a certain kind of the order, when and how the witnesses are to be produced, how the examinations are to be conducted. There is a kind of a order that has been already defined by the Indian Evidence Act. Dear friends, when we talk about the order, there are certain rules, regulations that are given either in the CPC, CRPC, the law, or there are certain customary kind of practices. We'll come to that point later on. My dear friends, Section 135 of the Indian Evidence Act provides for an order of production and examination of witnesses. So in what order the witnesses are to be produced and how the examination should be conducted, that kind of thing has been referred under Section 135 of the Evidence Act. What does it say? The section says that there are how the order of production of witnesses is determined. It is a matter of a law. If the CPC and CRPC provide for certain kind of a production of witnesses, that kind of thing is important, that is a law. What is the practice? What kind of practice is being followed in the court of law? It is a matter of privilege of counsel. It is a matter of skill and experience of the lawyer. Many more things that determine the order of production of witnesses before the court. See, there are certain laws that determine how the witnesses are to be produced, when they have to be produced. That is one thing. Sometimes there is a court practice which is not part and parcel of the legal rules framed under the law, but it is a matter of practice. Sometimes there are the certain privileges of the counsel. You might be knowing cricket, when to send the pinch hitter in slog overs. That is the sole discretion of whom? The captain and the management of the team. The same way, it is a matter of skill and experience when to put forward the witnesses when to produce the witnesses, that is also considered as a matter of privilege and matter of skill and experience of a particular kind of a lawyer. If there are no rules, if there is no any kind of a law, then it is the discretion of the court sometimes that has to provide a kind of an opportunity. Basically, it is not basically an opportunity, but it is a discretion of the court when to call the witnesses in the witness box. So what we have studied with the context of 135 section, that is what, firstly, there are certain laws, CPC, CRPC, for example, they determine how to produce, when to produce, number one. For example, in civil cases, the party bearing burden of proof examines the first, that is one. In criminal cases, it is the prosecution which examines the witnesses first. So therefore, if it is the plaintiff in civil case, the duty or the kind of right of that plaintiff to produce the witness first, that is what the order is. Similarly, in case if the lawyer, the advocate wants to produce the witness at a particular moment, he reserves that kind of right with him. So that liberty is available with that kind of a lawyer. Lastly, when there is no rule, no practice is there, which has to be followed, then the court also is having discretion to allow the production of witnesses. I'm having one video with you to share. Let me minimize this. Yes. Once again, I'm going to share the video. Can you see?
त्यागी जी, आप एक काम.
Are you able to see?
Yes, sir. Yes.
Yes, sir.
Okay.
Yes, sir. Yes,
Yes, sir. Yes, sir.
Okay.
Yes, sir.
आप विटनेस को बुला के लेके. Thank you, sir. राजपाल साहब, मैं परमिट कर रहा हूँ ना. बात खत्म हुई, मैं कर रहा हूँ. आप लेके आओ.
sir, I can't see the video.
Rules.
अरे मैं कह रहा हूँ ना, तो आप आने दो. आप बुलाओ, आप बुलाओ.
Rules do not permit it. You have to give advance notice.
राजपाल साहब, मुझे भी रूल मालूम है. आप जानते तो आप. राजपाल साहब, ये मेरा कोर्ट है. आपका क्लब नहीं. समझ में आई बात? Here only I can. हाँ? And I'm doing this. राजपाल साहब, आप बीच में बोलना बंद करो. अब देखो कंटेम्प्ट ऑफ कोर्ट कर रहे हो आप. राजपाल साहब क्यों बहस कर रहे हो? मैं बोल रहा हूँ, बैठ जाओ ना. प्लीज बैठ जाओ. राजपाल साहब, I'm ordering you, just sit down.
Yes, I will once again. Is the PowerPoint is there?
Yes, sir. The screen
Okay.
is visible now.
Yes.
Okay. So, with the help of this video, what we understand, there are rules of production of witnesses in front of a court under CPC and CRPC. Sometimes there is a practice. What kind of practice we can find? In civil cases, the party which is bearing burden of proof examines the witness first. So that party is under obligation, or the party is having exclusive kind of right to produce the witness in front of a court. In criminal cases, the right goes to the prosecution. Sometimes the privilege is also with the lawyer that I have already told you. And the last thing that was in connection with the video I stated was the discretion of the court. Here, in that particular kind of a clip of the movie, it was the discretion of the judge, that is the court, who asked particular kind of a party to produce the witness. So that we have to take into account. My dear friends, there are certain orders under CPC which are talking about how to produce the witness. That I'm not going to refer you. Order number 18 is there, 41 is there. You can refer it. I will not be emphasizing upon those things. But what I am saying, these are the rules, and the court is bound by these rules. But at the same time, taking into account the need, the court can exercise the discretion as well. The criminal procedure code is also having the kind of its own rules which allow the production and examination of witnesses. My dear friends, once whose responsibility is to produce the witness is very much clear, then we have to see the admissibility of evidence. When the witness comes with the evidence before the court, it is up to the judge to decide as to the admissibility of a particular kind of evidence. The judge is empowered to ask in what manner the evidence is relevant which has been brought by the witness. In order that proof may be confined to only relevant fact, and in no case the witness can give the evidence beyond the proper limits of the issues at the trial. That kind of boundary line which has to be obeyed by the witnesses. Thereafter, the judge decides as admissibility. He has to take due care, discretion while admitting the evidences before the court. And the judge reserves with him, the court reserves with it, the right to ask the question in under what section a particular kind of evidence is admissible to the concerned party which wants to bring the evidence before the court. Dear friends, we'll take example. If one of the party is willing that the court must consider a particular kind of a note as a dying declaration, that party, that lawyer or particular party wants the court to believe in a particular kind of a notebook or kind of a cheat which is being written with certain kind of information to be considered as a dying declaration. So it is necessary to prove the death of person whose writing is being displayed with the help of that piece of paper. So the court can ask the concerned party who is willing to prove the dying declaration. Before proving the dying declaration, that judge can ask to that party that prove the death of the person first, then we'll consider the dying declaration, because a cheat is there which is written by somebody which refers the cause of death or transaction that have resulted into death. That will not make that piece of paper as a dying declaration. But as soon as the death of the person who has written that piece of paper is proved, then only that sheet of paper becomes dying declaration. So that kind of right the judge reserves with him. Now we'll come to the order of examination of witnesses, and before that we have to understand what are the kinds of examinations. Dear friends, as I have stated, examination is nothing but a careful study of something. So what kind of study we are going to do under the law of evidence? That is the examination of the witnesses. That means the study of the witnesses. So there are, under section 137, three kind of examination we can refer: examination in chief, cross-examination, and re-examination. And in order, examination in chief comes first, that is followed by cross-examination, and lastly re-examination. So what these examinations are, that we will look into. Firstly, we'll look into the examination in chief. Dear friends, examination in chief in order comes first. So whenever there is a judicial kind of investigation, judicial proceeding that has to take place, that takes place in the court of law, when the witness is brought before the court, the first kind of examination is examination in chief. It is very important. Then who conducts this particular kind of examination in chief? The examination in chief is conducted of the witness by the party first who has called that particular kind of a witness before the court. The party which has asked, requested the particular kind of a witness to come before the court and give his witness, her witness, that party itself has a right to examine that particular kind of a witness first, and that is called as examination in chief. For example, in civil cases, if a plaintiff wants a particular kind of person to be produced as a witness in the court, then it is that plaintiff who is having right to examine firstly, and therefore it is called as examination in chief. My dear friends, what kind of examination in chief is? The questions and answers are so interwoven, put to build the story, the arguments that have been made in the plaint of written statement or in as per the arguments of the prosecution and defense respectively. So whichever the party has asked the witness to come and give a statement in the favor of that party which has called that particular kind of witness, the question and answers are so framed that whatever the plaint is stating, whatever the prosecution story is stating, whatever the defense story is stating, in accordance with the question and answers are being asked, and accordingly the witness is supposed to answer to strengthen the arguments that have been made under the kind of a stand that has been taken by a particular kind of a party in the court. During the examination in chief, the witnesses on oath have to state all the material facts within his knowledge. What I'm saying, whatever the witness has seen with his five senses, or rather experienced with his five senses. We have seen what is the definition of fact. The five senses that we are having, with that the person has witnessed a certain kind of the witness has experienced a certain kind of a fact. He has to tell the court about that particular fact, which is certainly a material fact within his knowledge. No imagination is allowed. What he has witnessed himself has to tell to the court. That is what is being done in examination in chief. Then it is basically considered as part and parcel of the judicial proceeding. My dear friends, I just referred you examinations. Examination in chief, cross-examination and re-examination. Keep in mind, examination in chief and cross-examination are considered as essential part and parcel of judicial proceeding. But re-examination does not have that kind of a status to be being called as a judicial proceeding. That we have to take into account. Now, what is the purpose of examination in chief? For what purpose the examination in chief is being conducted? It is conducted to take such a testimony for which the witness is called by the party. For what purpose the witness was called in the witness box by that concerned party? So that kind of party's advocate takes the testimony from the witness. So this is what the main purpose. Then another purpose is to extract the truth. Whatever the disputed legal, there is a legal dispute regarding the fact is there, the court need to come to the conclusion what is truth and what is untruth. What kind of truth prevails over there. In order to know, the court is getting the help. Rather, the parties, they want their position to be made clear in the court. Therefore, the truth must be extracted from the kind of a witness with the help of examination in chief. It also aims to prove the facts which bear upon the issue in favor of party. If X is the party, prosecution is there, which has asked an eyewitness of a particular kind of a murder, then that eyewitness, while being conducted, while the examination is in chief is being conducted, he is supposed to tell the court those facts which are very relevant with the story which is propounded by the prosecution. It also aims to allow only the evidence of fact and not of a law. For example, there is a witness and he is being called by the prosecution as a main eyewitness of a particular kind of a crime, that is murder. And if the witness comes before court and he tells, साहेब मी मर्डर पाहिलाय, 302 पाहिलाय, so such kind of testimony is not expected from him. It is up to the court to apply the law. A person cannot judge a law. He has to tell the court only the facts. म्हणजे तो जर असं म्हणत असेल, I saw X stabbing Y with the knife or kind of a sword. मी एकाला दुसऱ्याशी, आरोपीला दुसऱ्याला चाकूने भोसकत असताना बघितलं आणि त्यानंतर तो मेला, एवढं तो बोलू शकतो. But in no case he can state before the court that accused was doing 302. असं त्याला काय म्हणता येणार आपल्याला, he cannot apply the law. So he is supposed to adduce before the court only the evidence of fact and not of the law. My dear friends, if the party did not go for cross-examination, then relying on examination in chief is not safe. That was held in Gopal Saran versus Satyanarayan's case. You try to understand. We cannot judge a thing with only one view. We have to see the thing dynamically through various angles. Then only we can understand that particular kind of thing clearly. So if in any case, if the court has already finished the exemption in chief and the adverse party is not conducting a cross-examination of that witness, it would be fatal to administration of justice. That is what we have to take into account that was held in Gopal Saran's case. Dear friends, thereafter we have to march towards the cross-examination. In order, first comes the examination in chief and second thing is cross-examination. So in sequence, it is the second which comes after examination in chief. If the examination in chief is conducted by the prosecution, then the cross-examination of the same witness of prosecution has to be conducted by the defense. That we have to see, the opposite party, the adverse party. It is an examination of witness by the adverse party. What I said, in examination in chief, the particular kind of a party asks a particular kind of witness to testify. If the examination in chief is over, it is up to the witness is open to the opposite party, and the party, opposite party, adverse party has every right to cross that kind of particular kind of witness. So it is an exclusive right of opposite party to conduct cross-examination. It has to be conducted after the completion of examination in chief, and we have to understand what kind of questions are being allowed to be asked during cross-examination. Leading question. We have to see after the completion of these particular kind of examinations, we are going to see what kind of questions that are being allowed to be asked during various examinations. Maybe chief examination, maybe cross-examination. One of such category of question is leading question. So what is it that we will look in within a couple of minutes. So we have to understand basically the cross-examination comes next to the examination in chief, and opposite party conducts the cross-examination of the same witness was produced during the examination in chief. Dear friends, we have to understand one drawback in the context of not conducting cross-examination. What I said, I have already referred that Gopal Saran's case. If we are not, if the party, adverse party is not conducting cross-examination, then sometimes for the administration of justice, it would be fatal. What I said, both the sides must come into focus before the court. Then only the court can come to the proper conclusion. And if the adverse party is not conducting a cross-examination, that would be presumed that whatever the testimony that was given by the witness in the examination in chief, that has been totally accepted by the adverse party. Whatever the story that was argued in examination in chief with the help of witnesses, that is considered as accepted if no cross is conducted. That is what the effect of cross-examination and not examining the witness by adverse party. Dear friends, we'll move towards the another kind of important slide. What is the purpose? What is the purpose of conducting cross-examination? My dear friends, we know in picture there is a picture that is a gold which is being purified with the help of the kind of a fire. So when the gold is put on a fire, it is said that it is experienced that it glows. The impurities are removed. The impurities are removed with the help of heat. We can equate the examination to that of heat, the fire. आगीला अग्निपरीक्षा हा शब्द आपण ऐकलेला आहे. अग्निपरीक्षा, सोन्याची अग्निपरीक्षा, सोन्याला काय करते, निखरवते आणखी, त्याच्यामध्ये आणखी तेज झाळी येते. So the same thing we can apply with the help of in the context of cross examination. Why the cross examination is conducted? It is conducted to test the veracity of witness. Veracity means सत्यता. ती सत्यता पडताळण्यासाठी काय करण्यात येते? क्रॉस एक्झामिनेशन is being conducted. And in that kind of testing of veracity, if it is found that it is the witness who has already given his witness during the examination in chief is not credible, then with the very questions at the time of cross examination, his credit may be impeached. In order to impeach the credit of that witness, the cross examination is conducted. The another purpose of conducting the cross examination is to bring the suppressed fact into the focus. Sometimes during the examination in chief, the questions were asked in a such way that there were certain facts, they remained suppressed. They never came before the court. They never came in the light. So in order to bring those suppressed facts into the light, into the focus, the cross examination is conducted. And what I said, see, the scientist who is using his microscope to see the kind of microorganisms and thereby come to the conclusion. Unless and until he puts his efforts to examine very keenly those kind of a the specimens for his experiment, then he cannot come to the conclusion. The same way, without having cross-examination, the trustworthiness of the witness cannot be proved properly. So, my dear friends, we'll come to the next thing. The third category of the examination of witnesses is re-examination. So, in order, it is the last one. It is the third one. Firstly, examination in chief. Second is cross-examination, and the lastly is re-examination. It is subsequent to the examination, that is cross-examination. What happens in examination of chief? The kind of examination is conducted of the witness. Then during the cross, certain kind of contradictory statements or the facts, they come forward, and that may create a kind of a doubt towards the witness. And in order to settle that kind of a doubt, re-examination may be allowed. And that re-examination is conducted by the same party which has called that witness before the court first time, that is during the time of the examination in chief. And what is the purpose of re-examination? The purpose of re-examination is to remove the inconsistency between the kind of the statements that have been made by the witness during the examination in chief and cross-examination. Cross-examination आणि chief मध्ये त्याने जे स्टेटमेंट केलं ते कॉन्ट्राडिक्टरी जर झालं तर ते जे काही जो गोंधळ उडलेला आहे तो रिसेटल करण्यासाठी re-examination conduct होते. This is not considered as part and parcel of judicial proceeding. Judicial proceeding चा re-examination ला पार्ट मानण्यात येत नाही. Only examination in chief, and cross-examination, they are essential elements of judicial proceeding that we have to take into account. And that doesn't mean re-examination is not important. It is important because it is helping the court to remove the inconsistency. Basically, that particular kind of party which has conducted examination in chief getting a benefit out of re-examination, and the inconsistencies could be removed with the help of re-examinations. Now, my dear friends, what kind of questions that are allowed? Firstly, I will deal with what are the lawful questions, and then I will go for the leading questions. What kind of questions are allowed in a cross-examination? The questions must be lawful. Those questions which are not lawful, they cannot be allowed to be asked during the cross-examinations. So, what makes the question lawful? If the question is put in order to test the veracity of witness, then it can be considered as the lawful question. एखाद्या विटनेसची सत्यता पडताळून पाहण्यासाठी केलेला प्रश्न लॉफुल प्रश्न आहे. Sometimes the question to discover who the witness is and what is his position in the life. तो विटनेस कोण आहे आणि तो त्याच्या जीवनामध्ये काय करतोय, कोणत्या पोझिशनला आहे, हे विचारण्याचा प्रश्न सुद्धा लॉफुल आहे. But at the same time, we have to understand the questions which aim to shake his credit by injuring his character. कधी कधी विटनेसेसचं कॅरेक्टर सुद्धा तार करता येतं, त्याच्यावरती प्रश्नचिन्ह उभारता येतात with the permission of court, certainly, जर ते केसशी relevant असेल तर. If it is related with the case, then certainly it is allowed. And that question may also be considered as lawful. But we have to take into account, if it is a matter of inquiring, asking the question with regard to character of a person, such question should not be asked about the character of the prosecutrix in the rape cases. Rape victim लेडीला मात्र तिच्या कॅरेक्टर बद्दल प्रश्न विचारणं लॉफुल ठरत नाही, हे समजून घेतलं पाहिजे. And what are the questions which are being allowed to be asked at various kind of the stages of examination? That is, one of the examination is cross-examination, and that is nothing but whatever the questions, they help the kind of defense to impeach the credit of the witness. All those questions are considered as lawful. But at the same time, we have to take into account every time the court must be convinced whether the question is lawful or not. That is what the important point is. It is up to the particular kind of lawyer of the party to convince the court how the question is relevant and how the question is lawful. Dear friends, thereafter comes the important kind of concept, that is a leading question. Leading question. So section 141 of the Evidence Act speaks about that kind of a question. What is that? When the question itself suggests an answer, that kind of question is considered as leading question. If I am asking you, Dayanand College of Law, is it the name of your college? What you will answer? I want
Yes.
answer from you.
Yes.
मी प्रश्न काय विचारला तुम्हाला? तुमच्या कॉलेजचं नाव दयानंद लॉ कॉलेज आहे का? म्हणजे मी प्रश्न विचारत असताना तुम्हाला काय म्हणालो, उत्तर सुद्धा दिलेलं आहे तुम्हाला. My question itself is suggesting an answer to you. Do you get my point? When the question itself suggests an answer, that is a leading question that you have to take into account. Okay. Dear friends, the another important aspect with regard to the leading question is this kind of question can be freely asked during the cross-examination exclusively. Leading questions, they can be freely asked during cross-examination. And if the same leading question, they have to be asked during other examination, that is examination in chief and re-examination, then without permission of the court, such leading questions cannot be asked. लीडिंग क्वेश्चन म्हणजे असे प्रश्न जे स्वतः प्रश्नामध्येच उत्तर सुचवत असतात, ज्याला प्रश्न ज्याच्याकडून उत्तर अपेक्षित आहे त्याला उत्तर सुचवलेलं आहे, त्यांना लीडिंग क्वेश्चन म्हणायचं. आणि दीज क्वेश्चन्स कॅन बी फ्रीली आस्क्ड ड्युरिंग क्रॉस एक्झामिनेशन ओनली. अँड इफ एनी पार्टी वॉन्ट्स to ask the leading question during examination in chief or re-examination, then it is necessary that court must give permission to it. Otherwise, such question, leading question, cannot be asked during the examination in chief and re-examination. Dear friends, we'll take example. If a plaintiff has produced his servant as a witness for a particular kind of a case of him, plaintiff has produced his own servant as a witness to support his case. So accordingly, the plaintiff's lawyer has conducted examination in chief of that servant. When it comes to the cross examination, the adverse party's lawyer can ask the question, are you servant of the plaintiff? लक्षात घ्या काय म्हटलं त्यानं, प्लेंटिफचा तू नोकर आहेस का. आता लक्षात घ्या, द फॅक्ट विच इज ऑलरेडी प्रूव्ड, बिकॉज द प्लेंटिफ हू आस्क्ड हिज ओन सर्वंट टू कम as a witness before the court, that means the fact that the person who is a witness in the courtroom is the servant of a plaintiff, that has been already proved. So the facts which have been already proved, with regard to that, the leading question may be asked. So the cross questioning authority, that is the adverse party's lawyer, can ask that particular kind of witness that, are you servant of the plaintiff? So what he will naturally answer, yes, I am the servant of plaintiff. So that is what is supposed to be asked in the context of a leading question. But at the same time, it won't be called as a leading question if the adverse party is asking the question to the servant, how long have you been in the service of the plaintiff? Because that fact of the service of that particular servant is not necessary for a particular case, and that has not been proved. Therefore, whatever the facts that have been already admitted before the court, proved before the court, with regard to that, the leading questions may be allowed. Dear friends, leading questions must not be asked if that is objected by the adverse party. Many times you might be watching movies and you come across with one kind of statement, an argument. Objection, my lord. Objection sustained or objection overruled. Objection sustained केलं तर प्रश्न विचारता येणार नाही. Objection overruled केलं